Welcome to another Travel Risk Management Solutions presentation. In this presentation we will cover duty of care and how not meeting your duty of care could be used to prove negligence. Firstly, negligence is defined as the failure to do something that a reasonable person would do which resulted in a person suffering damage or loss. To be successful in a negligence claim, the following must be proven. A duty of care was owed, there was a breach of the owed duty of care, and that the breach resulted in damage or loss as a direct result. The claimant must go through a 6-stage process to prove negligence against the defendant. Step 1. The claimant must prove that the duty of care was owed, and the claimant must determine the standard of care that was owed to them. In the case of health and safety, both these points are immediately met as health and safety is a non-delegable legislative duty which is owed to people that carry out work by the organisation that they work for. Step 2. The claimant must prove the standard of care provided was below the standard of care required. The standard of care required is based on the risk of an event occurring, the consequence of it occurring, and the cost to control the event, i.e. is it reasonably practicable to control that level of risk. Step 3. The claimant must prove that comprehensible damage occurred. This could be physical injury, it could be mental injury, and please note also that dependents could also claim negligence on behalf of the claimant. So in the case of Annetts versus Australian Stations, 2 station hands actually perished while working on the station, and their family brought a successful negligence case against the station which resulted in their death. Step 4. Prove that the damage was a direct result of the breach of the duty of care which was owed. So you must prove that it was caused by the person or the company, and the but-for test would be used here. So would the injury have occurred but for the defendant's action? And in the case of travel for work purposes, this would be very clear-cut that the damage would not have occurred because the person was travelling for work. However, it should be noted that there is a grey area where workers that travel for work may extend their period to do personal travel either before or after the reason for travel for business purposes. Step 5. The claimant must prove that damage was reasonably foreseeable. So could the damage be anticipated as a consequence of the breach? Was the damage not out of the realms of possibility? And has it been known to occur before? Essentially, this would lead directly back to the risk register or the risk assessment that was done prior to travel. So it pays to be thorough and complete here. Do not just go through the motions and use a tick and flick, because any admissions could be used against you if the claimant was injured during travel. Step 6. Are there any defences that the defendant could use to counter the claimant's accusations? And here we're talking about contributory negligence and voluntary assumption of risk. So did the actions of the claimant contribute to the injury? So just to recap, to be successful in a negligence claim, the following must be proven. The duty of care was owed, there was a breach of the owed duty of care, and damage or loss was caused as a direct result of the breach. Thank you once again for listening to our presentation about duty of care and negligence. If you require any more information, please contact us on Travel Risk Management Solutions, and we'll be most happy